Okay, thank you, parties. And we were at the point of cross-examination of Officer Lefebvre by the defense. Ms. Latar, are you ready to proceed?
I am, Judge.
Okay, so go ahead, please.
And good morning, Sergeant Lefebvre.
Good morning.
I just have a couple questions for you. So on direct examination, you testified that you had a conversation with Mr. Martinez.
Yes.
And did he explain to you why he was facing the incorrect direction?
Yes, he lost power.
Mm-hmm. And his hood was up when you approached him?
I believe so.
And he told you that he had drank after his car stalled.
Not after his car stalled. He drank prior to his car being stalled.
And so it's your testimony today that he did not tell you that he had drank after his car stalled?
Just so we're clear, after his car stalled?
Yes.
Is when I made contact with him, so I guess technically he told me he drank after his car had stalled because it was already stalled.
Yes, sorry.
But no, he did not drink there while his car was stalled.
And that's your testimony today, so
Correct.
That's what he told you?
Yes.
And we can't confirm the conversation that you had with Mr. Martinez?
No, I think my little mic was in his little cradle.
Yes, your lapel wasn't on during the interaction?
Correct.
Okay, no further questions for this witness, Judge. No further questions in regards to the reasonable suspicion to expand motion.
Okay, and so is there any redirect on Ms. Maurer? Okay, go ahead.
What direction did he say he was coming from again before he turned?
He was traveling eastbound on Marquette, approaching 2nd Street. So he was going the opposite way on Marquette, and then he made a left-hand turn to travel north on 2nd Street, but he was in the southbound lanes on the left-hand shoulder.
Did he say why did he say why he was traveling the wrong way on a one-way street?
Did not say why. He told me that his car lost power.
Do you see any alcohol containers in the defendant's vehicle while you were on scene?
I did not.
The state has no further questions for this witness.
And parties want to reserve Sergeant Lefebvre?
Defense would like to argue reasonable suspicion to expand at this point, but I don't believe that defense has any more questions for Officer Lefebvre for the pendency.
Okay. And state, are you asking to reserve Sergeant Lefebvre for any other
testimony into trial?
I imagine defense would be asking that this testimony be incorporated into the trial, correct?
Yes, Judge. I don't have any hearsay concerns with this situation.
Okay. Okay.
The state does not need to reserve Officer Lefebvre.
Okay. Thank you, Sergeant Lefebvre. Have a good day, and you're excused.
Your Honor.
Okay. Thank you.
At this point, Sergeant Lefebvre did just testify that he was the reasonable suspicion to expand officer. So defense would ask to argue the reasonable suspicion to expand motion at this time.
Okay, sure. So let's go ahead and hear that argument first, and they'll hear the state's response, and then we'll see where we go from there.
Thank you, Judge. So at this time, Judge, as
Ms. Maurer, you can go ahead and have a seat at council table, and since defense is at council table, then just make yourself comfortable, and that's fine. Thank you. Okay.
I'm sorry, I should have asked. Would you like me to stand, Judge?
No, that's fine. Go ahead.
Okay. Regards to the reasonable suspicion to expand motion. So defense did file a written motion in front of Your Honor, and the state did respond to the written motion. In defense's written motion, we did kind of draw two different questions that I want to raise at this point. The first was generally the lack of reasonable suspicion to expand that I will address, and also the fact that Officer Lefebvre did not have his lapel video on And so this court has granted defense an adverse inference in regards to Officer Lefebvre's testimony. I also did want to draw the attention that the state's response as to reasonable suspicion to expand does not really at all address Officer Lefebvre. So I will just make my argument and then I guess respond orally to whatever the state responds to my argument orally. So first, Judge, as this court has found, defense would be asking Your Honor to apply an adverse inference to Officer Lefebvre's testimony. Defense's contention is that that would mean that anything that on the lapel video we could show, or that Officer Lefebvre could show, would be assumed to be detrimental to the state. And I believe that is what the case law says. So
What case are you citing?
Where, Judge?
Okay, just to be clear for the record.
Yes, of course.
Okay.
And so to go through Sergeant Lefebvre's testimony, he does note for the reasonable suspicion to expand, bloodshot, watery eyes, and an odor of alcohol. Defense would ask Your Honor to apply an adverse inference for the bloodshot, watery eyes, as if Sergeant Lefebvre's lapel video was on, we would be able to see the bloodshot, watery eyes in the lapel video. Now, I understand, and defense would not ask for an adverse inference as for the odor, as I don't believe that a lapel video would or would not show the odor. So I understand direct testimony about that. I would contend, though, Judge, that there was nothing on direct testimony about where that odor was coming from. In Katz, which is a New Mexico, I believe, Supreme Court case regarding reasonable suspicion to expand, where the court did find reasonable suspicion to expand, but did state there was not much there. There was testimony at least about the odor of alcohol, where it was emitting from, and bloodshot, watery eyes. There was also admissions in that case.
What case was you citing again?
In Katz, I want to say it's state of New Mexico versus Katz. I can look up the...
Did you cite that in your motion? I don't think I saw that.
I may not have, Judge. I admittedly did not file this motion.
Okay.
So I just wanted to address to Your Honor that as for reasonable suspicion, and I know that Your Honor has heard many DWI cases, and it's very common to hear bloodshot, watery eyes, odor of alcohol, slurred speech. There was no testimony about that, but I did just want to go through the normal RSC points. And here we heard bloodshot, watery eyes, which defense would be asking Your Honor to apply an adverse inference to because we don't have lapel video here. So I believe that this court should take anything that we could confirm with lapel video and apply it against what the state would contend. As for the odor of alcohol, there was no testimony about where the odor of alcohol was coming from. He did testify on direct that there was an odor of alcohol, but he did not testify to really any more details regarding that odor at all. In addition, Judge, there were no admissions to Officer Lefebvre. It's defense's contention, and I know that Your Honor heard this at the Chenard-Ware motion, but defense contends that a different conversation took place to Officer Lefebvre than the one that Officer Lefebvre is contending happened. And I believe that was the basis for Your Honor finding for an adverse inference, was that defense contended that a different conversation happened, and we cannot confirm that because of a breach on the state and on Officer Lefebvre. So as far as we have any information, there were no admissions to Officer Lefebvre about drinking. There was no admissions, there was no testimony given today or any testimony about a timeline of when Mr. Martinez drove. Sergeant Lefebvre did testify that he had his car had stalled out and he had pushed or gotten the car to the 2nd Street, but there was no testimony about how long ago that was. Sergeant Lefebvre didn't say if he had asked that question, or there was just no testimony at all to the timeline. So really what Sergeant Lefebvre testified as a reasonable suspicion to expand this investigation to a DWI was bloodshot, watery eyes, and a general odor of alcohol. defense would ask that Your Honor find an adverse inference for the bloodshot, watery eyes, and so with that, there would only be a general odor of alcohol, and that was the only thing that Sergeant Lefebvre was making a decision to expand this investigation into a DWI. So, again, no admissions, no testimony to timeline, no testimony to how long ago he had driven, or when he had allegedly drank. So defense at this time would ask that Your Honor grant defense's motion to suppress anything past the point of expanding this investigation past the DWI, as Sergeant Lefebvre did not have reasonable suspicion and articulable facts to expand the investigation into a DWI investigation through his calling out to Officer Lujan.
And State, your response?
Yes, Your Honor. For the expansion of reasonable suspicion under State v. Candelaria, it says that as the situation develops, officers may expand an investigation to answer any new, reasonable, and articulable suspicions that arise during the course of their lawful activity. Sergeant Lefebvre testified that the defendant, when he came upon him, was sitting on 2nd Street, facing the wrong direction from the direction that the lane is supposed to travel in. Officer Lefebvre also testifies that the defendant told him that he had been traveling the wrong way on a one-way street. Officer Lefebvre testified to bloodshot, watery eyes and to a strong odor of alcohol, not a general odor of alcohol, a strong odor of alcohol. Officer Lefebvre also testified that he did not see any alcoholic containers in the defendant's vehicle while he was on scene. The court has given to defense an adverse inference because the lapel video is missing, which means that we don't have an audio recording of the interaction between Officer Lefebvre and the defendant. And there are certain things that you won't be able to see on that video that is missing, and there are certain things that you won't be able to hear because it wasn't recorded. But we do know that the vehicle was in the wrong travel lane, facing the wrong direction. We also know that there was a strong odor of alcohol, which is not something that you can record on a lapel video. Given the information that the vehicle is facing the wrong direction, we have a concern. Potentially that concern could be assuaged by the vehicle being out of service. And the defendant does tell Sergeant Lefebvre that there was something wrong with his vehicle, so he stopped at that spot and his hood was up. However, strangely, that vehicle is still in the wrong lane of travel, facing completely the wrong direction. Furthermore, the officer smells a strong odor of alcohol, which means that he has to expand his investigation to answer a new, reasonable, and articulable suspicion, even though he's provided with a reasonable explanation as to why a vehicle would be stopped. He's not provided with a reasonable explanation as to why that vehicle is stopped facing the wrong way. And there's still that strong odor of alcohol that he has to follow up on. If he were doing his job, he has to follow up on it. If he chooses not to do his job, then he doesn't follow up and no investigation ensues. The point of expansion of reasonable suspicion is that there is a reason to launch into a DWI investigation. In this instance, we have a reason to launch into a DWI investigation. We have a strong odor of alcohol. We have bloodshot, watery eyes. We have admissions that he was driving the wrong way. We have admissions that he stopped in that incorrect lane of travel. And we have him in the incorrect lane of travel, facing completely the wrong direction. However, Your Honor decides to apply that adverse inference, if it be against the bloodshot, watery eyes, even potentially against the statements that the defendant made about traveling on the wrong way on the one-way road. we still have a vehicle facing the wrong direction, and we still have a strong odor of alcohol. Based on that, it's Officer Lefebvre's job, Sergeant Lefebvre's job, to follow up and call for a DWI unit because he can't stay and perform the investigation himself. Therefore, there was reasonable suspicion to expand, and it was appropriate to begin that DWI investigation. Therefore, the state asks that you deny this motion and that we continue.
Yes, Judge, I just wanted to point out a couple more things. So defense did not file an RS motion in this case, and I believe that there is RS for Sergeant Lefebvre to investigate into why there is a car parked on the side of the road, not in the roadway, but on the side of the road facing the wrong direction, and that answer is given to him. I'm not necessarily contending that Sergeant Lefebvre should not have tried to investigate more. I'm saying that he did not do so before calling a DWI officer. He could have, if he was concerned about a DWI, he could have asked any number of questions to Mr. Martinez, and he did not. He called out for a DWI officer less than a minute after coming upon Mr. Martinez. With those facts, he had a car stalled out, explained why, not in the roadway, but on the side of the road facing the wrong direction, which is explained why, and he had a odor of alcohol. By general, I just meant not emitting from a certain area. And that's all he had. He could have asked Mr. Martinez a number of questions, and it would have taken not even 3 seconds more. And with that information, then I would understand expanding into a DWI investigation. Defense's contention here is that there was not due diligence done by Sergeant Lefebvre to expand into a DWI investigation, so all he had was a stalled out car and a general odor of alcohol. He could have asked any number of questions, used any, information that he then got to then call out for Officer Lujan. He did not meet his constitutional requirements for reasonable suspicion to expand with the facts that he had by the time he called out for a DWI officer.
Okay, parties, I think what I'm going to do is I'm going to go back to my office. I want to replay parts of the record of Sergeant Lefebvre's testimony and take a little bit of a break since we've had a long morning before I come back with my my ruling on defense's motion. So I'm going to do that. I'll be back before 12. It may be 5-10 minutes, but I'll be back before 12 definitely.
Understood, Judge.
Okay.
Thank you.
Okay, thank you, parties.